Hello everyone, my name is Desmond, and today my group and I will be discussing damages in contract law. We will explore three statements: nominal damages, the relationship between mitigation and a breach of contract, and the burden of proof for establishing a causal connection and assessing remoteness of loss. Let's dive into these aspects of damages in contract law and gain a deeper understanding of their significance. Firstly, damages are the primary remedy commonly awarded by courts in cases of contract breach. Regardless of the severity of the breach, an innocent party possesses the right to seek compensation for all losses incurred as a direct result of said breach. Section 74 of the Contracts Act 1950 states that the law on damages in Malaysia. Section 74 sub 1 of the Act states that in cases of contract breach, the aggrieved party is entitled to receive compensation for the loss or damage caused by the breach. This compensation covers losses that naturally arise in the ordinary course of events or were reasonably foreseeable at the time of contract formation. Section 74 sub 2 of the Act states, however, compensation is not granted for remote or indirect losses resulting from the breach. Section 74 sub 3 of the Act states, similarly, when an obligation similar to a contractual one is not fulfilled, the injured party has the right to seek compensation equivalent to what would have been awarded if a contract had been breached. In the case of Architect Tenggara Sdn Bhd and Mid Valley City Sdn Bhd, the Federal Court Judge Augustine Paul made an observation regarding Section 74 of the law. He referred to the commentary by Pollock and Mullah on Section 73 of the Indian Contract Act, which is equivalent to our Section 74. The commentary states that the general principle for assessing damages is compensatory in nature. In other words, the aim is to place the innocent party in the same financial position as if the contract had been fully performed, to the extent that monetary compensation can achieve that goal. Next, important principles in the assessment of damages include remoteness of damage, which determines if the damage was reasonably foreseeable by the defendant; mitigation of loss, which requires the claimant to minimize their losses. Other principles include the date of assessment, taxation of damages, and contributory negligence. Type of losses and damages include pecuniary loss, which are monetary losses, such as financial expenses or property damage; non-pecuniary loss, which are damages affecting quality of life, like pain and suffering or emotional distress. Specific damages include general and special damages, nominal damages, exemplary damages, and aggravated damages. Additional types of damages are liquidated damages and deposits. To successfully claim damages, several conditions must be met, including the existence of a valid contract, the absence of illegality or voidness in the contract, the demonstration of a breach of the contract, and the establishment of a causal link between the breach and the loss suffered.
Hi, my name is Lee Yishan. Today I'm going to present about nominal damage. First of all, nominal damage are recognized in Malaysia contract law, although it's not expressly stated in statutory provision. This can be seen in the case of Syarikat Kemajuan Khairy Sdn Bhd and Subin Abdullah and another, where the court highlighted two circumstances that justify a judgment of nominal damage. First, when there is no actual loss or damage, such judgment will be for nominal damage only. Or, second, where damage is shown but its amount is not sufficiently proven. The absence of evidence of such amount of loss would entitle the plaintiff to nominal damage only. Next, in Huban and Tan Tiang Kee, the plaintiff sued the defendant for the loss of opportunity to purchase the land. The Court of Appeal recognized the breach of contract based on the facts. However, because the plaintiff suffered no monetary loss, the court merely awarded nominal damage of $10. Nominal damage aims to acknowledge the breach and vindicate the injured party's right, but the amount awarded are usually small. A plaintiff who cannot show actual loss may only be awarded nominal damage, even though the defendant clearly did something wrong or illegal. The availability and amount of nominal damage depend on the specific circumstances and court discretion. Nominal damage are usually awarded in two situations. First, if the plaintiff has failed to present evidence of his or her loss, or if the plaintiff has not suffered physical loss but has been victimized in some way. The main reason behind nominal damage is merely to acknowledge that the plaintiff has proved his case and won. In the case of Pangkaran Prima Sdn Bhd and Iswara Bena Sdn Bhd, the Federal Court stated that nominal damage according to past Malaysian court decision can range from RM10 to RM2000. Thank you, that's all for my part.
I am Yong Pei Ying. So what is mitigation? Mitigation is a legal principle that requires the innocent party to take reasonable steps to minimize the losses or damages caused by the breach. Basically, the innocent party must take reasonable steps to reduce their losses and stay away from any extraneous or excessive damages that could have been avoided. And a breach of contract happens when one party fails to perform its contractual responsibilities. It can involve a lack of performance, an imperfect performance, or a performance that falls short of their expectations. The innocent party may be entitled to certain remedies or damages when a breach occurs. The relationship between them is minimizing damages when a breach of contract occurs. Mitigation is closely related to breach of contract because it is an obligation put on the innocent party. They have to take reasonable steps to minimize or mitigate their damages. In the case of Goh Yew Chew against Sona Petroleum Berhad, the plaintiff and the defendant engaged into a stock purchase agreement. Later, the defendant broke the terms of the contract by failing to deliver the shares as promised. The plaintiff claimed the breach caused damages. The court held that the plaintiff had the responsibility to mitigate damages and he had failed to do so effectively. The court emphasized that the plaintiff should have taken reasonable steps to minimize his losses by selling the shares in open market when he had the opportunity to do so. Instead, the plaintiff held onto the shares, allowing the losses to accumulate. As a result, the court limited the damages awarded to the plaintiff based on his failure to mitigate. The court highlighted that the principle of mitigation requires the innocent party to take reasonable steps to reduce their losses.
Hi, my name is Lim Kang Jae. So first and foremost, the principle is that a plaintiff cannot recover damages for losses where they should have avoided and refrained from taking unreasonable steps that could increase the loss. In Khoo Tang Sui and Chan Chow Hee, the defendant consented to tow the plaintiff's log from Sungai Sugut to his log pond in Sandakan. The defendant was towing 82 logs in all. However, many of the logs came loose due to a severe storm. So only 42 logs were later found. So for the loss of 40 additional logs, the plaintiff filed a claim. The defendant asserted that the logs were lost in a sea storm as a denial of the plaintiff's claim. The court determined that the defendant had failed to take reasonable precaution to minimize the damages since in a towing contract of this sort, a storm must logically be anticipated and would have to be guarded against, especially in the open sea. Secondly, if an innocent party had avoided a loss or damage, such damages for that loss are then not recoverable. For instance, in the case of Gerbuder, Metalman, GmbH Company, and NBR London Limited, the court held that if the innocent party is successful in preventing or mitigating the loss or damage, he cannot be awarded damage for such losses or damages if the innocent party is unsuccessful in preventing or mitigating the loss or damage. Last but not least, if such party by taking a reasonable step to avoid or mitigate the loss or damage incurs further loss or expense, the innocent party may recover the amount of money spent. In general, this principle might be contradict with the second principle, where such amount used to mitigate or avoid losses might not be recoverable. However, here stated that in order to recover the amount of money spent in mitigating, the innocent party must ensure that the action he takes in mitigating the losses or attempting to mitigate the losses is reasonable. In the case of Hofberger and Esker International Bloodstock Brewery Limited, the plaintiff spent a lot of money keeping the horse in the hopes of selling it for more money after the defendant broke their agreement to buy the horse. Then after a year, the horse was eventually sold at a significantly lesser price. Then the defendant had acted reasonably, thus the court granted the claims of loss of profit as well as the cost associated with maintaining the horse for a year. That's all for me. Thank you.
Hello there, my name is Ahmad Nabil. Let us dive into the third question. The claimant or plaintiff must establish a sufficiently strong causal connection between the breach of contract and the loss claim that the loss or damages is not too remote. We will split this statement into two parts. Statement 1, I will be looking into the claimant or plaintiff must establish a sufficiently strong causal connection between the breach of contract and the loss claim. The following is the preface of the analysis. The statement calls for the establishment of causal connection in breach of contract claims. Causal connection is essential for recovering damages. Let us begin with analyzing relevant statutory provisions. Although there are no specific provisions in the Contracts Act 1950 that explicitly addresses the concept of causal connection in breach of contract, the principle is derived from common law and is widely recognized and applied in contract law. In order to recover damages for breach of contract, the plaintiff must establish a strong relationship of cause and effect. The claimant shall hold the burden of proof to demonstrate the breach caused the loss or damages suffered. The causal connection must be sufficiently strong to show that the loss claimed was a natural and foreseeable consequence of the breach. To strengthen our understanding, we shift the focus to judgments in case laws. We will first look at the common law case of Hadley and another and Baxterdale and others. It is a landmark case that establishes consequential damages from breach of contract. The case involves the plaintiffs who operated a mill and the defendants who were the carriers. The mill's crankshaft broke, and the plaintiffs engaged the defendants to transport the broken shaft to a manufacturer to repair. However, the defendant delayed the delivery of the shaft, causing the mill to remain inoperative for a longer period than anticipated. The court held that when determining the measure of damages for a breach of contract, the party in breach is liable for losses that the parties should have reasonably foreseen at the time of entering into the contract. From this information, it shows that a breaching party is liable for all losses that the contracting parties should have foreseen. The case essentially demonstrates the requirement of foreseeability in establishing the causal connection. In Malaysia, we have the case of MSM Malaysia Holdings Berhad and others and Transnational Insurance Brokers M. Sundian Berhad. This Malaysian case is in reference to Halsbury's Law of Malaysia. The principle of the case is that plaintiff must prove on a balance of probabilities that the breach caused the injuries. The application of the but-for test was determined that injury would not have occurred but for the defendant's breach of duty. Expert evidence in resolving causation issues, especially in medical negligence cases, is important. However, the outcome of the case provides that the court finds that the plaintiffs are unable to prove the balance of probabilities that the defendant had breached its duties against the plaintiffs and that the damage is in a way attributed to the defendant. The court therefore ordered that the suit be dismissed with cause. We are of the opinion that establishing a strong causal connection is vital in breach of contract claims. Burden of proof lies with the claimant to demonstrate the connection. Consideration of foreseeability and natural consequences of breach and expert evidence can be influential in establishing causation. That will be all from me. I will pass it on to the second presenter for this part.
Greetings, ladies and gentlemen. I'm Devesh Kumar, and today I'm going to talk about the remoteness of damages. So, what is the remoteness of damages? Well, fear not, because the definition of remoteness of damages is already stipulated in Section 74 of the Contracts Act 1950. Section 74 basically states that when a contract is breached, the injured party can only claim for damages that occur as a natural consequence of breaching the contract, and said damages shall not be too vague. This principle has been further provided for in the case of Hadley and Baxterdale. For this case, the court held that parties are only to be held liable for circumstances they can foresee during the formation of the contract. Another instance where this principle can be seen is in the case of Victoria Laundry and Newman Industries. In this case, damages were granted to the defendant on the grounds that the damage suffered was foreseeable and not too remote. There are two commonly used methods by the Malaysian court to determine whether a contract was foreseeable or too remote. The first of which is the direct natural consequences test. In this test, the court considers whether the damage is a reasonable and natural cause of action for the breach. Besides that, the second test the Malaysian courts employ is the reasonable foreseeability test. The following test is used by the court to consider whether or not a damage suffered was foreseeable at the time of the conception of the contract. The practicality of said tests can be seen in the case of Monsoon Metal Industries and Siu Fuk Chuan. In the following case, the court employed the use of the foreseeability test to determine whether the damages suffered in the contract was foreseeable at the time of the conception. To prevent such issues from happening, the parties in a contract should include certain clauses. This can help limit or exclude certain type of damages. However, it's worth mentioning that any clause set in a contract must be clear and unambiguous. In conclusion, understanding the principles of foreseeability and natural consequences is vital for you, the contractor, to protect your best interest. That will be all from me. Thank you for lending your ears and have a good day ahead.
In conclusion, under the Contracts Act 1950 in Malaysia, damages for breach of contracts are available as of right, even if no actual loss has been suffered. In such cases, nominal damages may be awarded to acknowledge the violation of a legal right. The innocent party is also obliged to mitigate their damages by taking reasonable steps to minimize their losses. Furthermore, the claimant or plaintiff must establish a strong causal connection between the breach of contract and the loss claim, ensuring that the losses are not too remote or speculative. These principles aim to provide fair compensation for breaches of contract while preventing unjust enrichment and discouraging parties from breaching their contractual obligations. Thank you.